Good morning, everyone, and welcome to this webinar. I'd like to welcome everybody on behalf of McInnes Cooper and Megan Thompson and myself to this webinar. On February 15th of 2023, just 5 weeks ago, the New Brunswick adjudicator issued an award that has raised some very important and timely issues that we're happy to discuss today. For those that aren't aware, you can see on the screen that arbitrator George Phillider issued an award involving the New Brunswick Health Authority. Some are saying it's the largest compensation amount ever awarded in New Brunswick. The total award is about $2 million. There's really three issues with respect to that award that may impact all of you in your day-to-day business as an employer. And those three issues would be with respect to written employment contracts versus oral employment contracts. It has to do with fixed term contracts and the relevance of those, and it has to do with the method of termination, aggravated damages, or what many of us call Wallace damages. And those are the three issues that we're going to talk about today. With respect to the case itself, for those that aren't aware, the CEO of the Health Authority was terminated after less than a year in what was a 5-year contract. At the time he was hired into the position, he was hired based on an oral discussion that he had, and was told that he would have a 5-year deal. And then he was presented with a written employment contract, and the written employment contract contained a termination provision, which his lawyers argued was not mentioned at all during the oral discussion. There was no additional consideration for the termination provision in the written contract. Mr. Dornan did sign the written contract and then was subsequently terminated in accordance with that written contract, and the arbitrator determined that the written contract was not valid for reasons that we'll talk about. He determined that the oral contract governed, which was a fixed term contract, and that the New Brunswick government had to pay out the remainder of the fixed term contract, the remainder of the full 4 years or such that were left on the contract, which is why the number gets so big. And then he also was asked, and then he also awarded aggravated or Wallace damages for the method of the termination, because Mr. Dornan was terminated by a phone call in a parking lot just prior to the news conference that announced his termination. So he was awarded aggravated damages of about $200,000 for the method, a method of termination. All of three of those issues raise a lot of interesting questions for us, and what we're going to talk about today, and what the lessons learned are from that decision. I will say off the top, perhaps not very surprising to those of you who know me, that there's a lot of parts of the decision that I don't agree with, that perhaps are troubling for those of us who practice in this area. Certainly the first issue and the third issue are very troubling to me. Aggravated damages is very troubling, as is the fact that that the written contract that Mr. Dornan signed shortly after commencing employment was found not to be a valid contract. I would suggest that it would be very commonplace that people would expect that the written contract that they receive would contain a termination without cause provision. So I'm troubled by that aspect of this decision as well. But with that, we'll move forward. We'll start with a poll question, so we can be interactive here. Does an employment contract have to be in writing to be enforceable? You can click on your answers and submit them, and then we'll see what the results are, and we'll move on from there. Okay, we'll see what the results are. There certainly the majority of folks have said no. Certainly, as we'll talk about now, an employment contract does not have to be in writing to be enforceable. So most people certainly have that correct. There's many of you out there who have employment contracts with your employees that are not in writing, but the whole employment relationship is a quote-unquote contractual relationship. In any event, whether or not it's written down, is irrelevant. But as we'll talk about, it's certainly always better to have a written contract. So with that, I will turn it over to Megan.
Great, thanks, Ian. So as Ian just mentioned in response to that poll, an employment contract does exist between an employer and an employee, regardless of whether its terms are agreed to in written form or by way of oral agreement. And an oral agreement will be a contract so long as it satisfies the necessary elements of contract formation, including offer, acceptance, consideration, and certainty of terms. One of the big advantages of a written employment contract, obviously, is that it can clearly set out in an enforceable way the respective rights and obligations of the employer and the employee. And we certainly recommend that all employers have written employment contracts in place with all of their employees. But that being said, although they may be more difficult to prove, oral agreements are no less enforceable than written agreements. But still, they do increase the potential for a misunderstanding between the parties about meaning of terms, and they may leave out certain important terms of employment that could otherwise be clearly outlined in a written contract. In this present case, the employer's first and biggest mistake was a common one. It introduced a written employment contract and an important new term after it had already entered a verbal contract with Dr. Dornan. Where a verbal employment agreement already existed, the employer would have been required to provide fresh consideration in order to make modifications to the terms of employment with a written contract. Consideration is a legal term, which in this context basically just means a new benefit to which the employee was not already entitled to under the verbal agreement. So looking at what happened in this circumstance, the employer and Dr. Dornan negotiated the terms of Dr. Dornan's contract verbally over the course of several weeks. The uncontested evidence at the hearing demonstrated that the parties had discussed all of the essential elements of Dr. Dornan's employment, including salary, benefits, a car allowance, pension, and the fact that the offer was for a 5-year term. They eventually reached agreement during an in-person meeting over dinner, and they agreed that they would be in touch to firm up the details. A few days later, in a text message, the employer advised Dr. Dornan that there would be an increase to his salary in lieu of a pension, to which the doctor responded, "We have a deal." The employer responded then saying, "Love it, it's a go," thus confirming their intentions to enter into a contract based on all of the terms that had been worked out during their oral negotiations. The very next day, the province shared 2 press releases to announce that Dr. Dornan had been appointed as CEO. So, like Ian mentioned, it's important to note at that point, no mention apparently had been made during verbal negotiations about a termination clause that would limit the compensation that the employer would pay to Dr. Dornan if it terminated his employment on a without cause basis before the 5-year term ended. 2 weeks after Dr. Dornan had started working, the employer presented him with a written employment contract. That written contract included the terms that the employer and Dr. Dornan had allegedly never discussed verbally, including that without cause termination provision. The employer did not encourage Dr. Dornan to seek independent legal advice on the contract, and he didn't. And the employer also did not specifically draw his attention to the addition of a termination clause in that written agreement. Dr. Dornan proceeded to sign the written contract, and at the hearing, he said that he felt he had no choice but to sign that written contract, as he had already left his previous job and his previous position had been filled. So he had no choice but to stay in his present employment arrangement with the province. When Dr. Dornan sued the employer for wrongful dismissal, the employer tried to rely on the termination clause to limit the compensation it had to pay to Dr. Dornan. The employer's arguments ultimately failed, and the adjudicator decided that the written contract and the termination clause in it were not enforceable because the employer and Dr. Dornan had already agreed to the contract terms verbally, and the employer didn't offer Dr. Dornan any additional consideration or benefit in exchange for agreeing to terms to modify his terms of employment. While the employer attempted to argue that Dr. Dornan was a sophisticated employee in a senior management role, and therefore the fact that he signed this contract should be determinative, the adjudicator actually disagreed. And although it may seem odd for the CEO of a major health network in this circumstance, the adjudicator called Dr. Dornan unsophisticated and found that he was unlikely to have understood the effect of the termination clause. He also noted that Dr. Dornan was in a vulnerable position as he had already quit his job and his prior position had been filled. Now, in its final argument to attempt to establish consideration, the employer argued that its agreement to pay Dr. Dornan's professional fees was consideration because it was a new benefit that they were agreeing to provide and had not previously been discussed during their oral negotiations. Unfortunately, that argument failed again, and the adjudicator rejected this because the offer to pay the doctor's professional fees happened after the employer presented Dr. Dornan with the written employment contract. And the payment of the professional fees were in no way referenced in that written contract or linked to the written contract. The evidence just didn't show that the employer had offered to pay those professional fees with the intention that they were going to constitute consideration for new terms, including that termination provision. So as a result, the written employment contract was ultimately held to be unenforceable due to the absence of fresh consideration in exchange for new contractual terms. So what does that mean for you as an employer? There's a few lessons that you can take away in terms of the timing of signing contracts and providing fresh consideration. At law, you have a contract with every employee, whether it's in writing or not. But as we said, it's often a lot more difficult to determine the terms of a verbal contract. And for that reason, a well-drafted written employment contract, including an enforceable without cause termination clause, is a crucial element to protect your interests as an employer. But even the best drafted written employment contract might not be enforceable if it's not signed before the employee starts working. The timing of entering into that contract does matter. So there's a few recommendations that we have. The first being making a conditional offer when you're engaging in those verbal negotiations with an employee before they start work. If you reach a verbal agreement on employment terms with a prospective employee, be clear that it's conditional on the employee signing a written employment contract in a form that is acceptable to you, and clearly indicate in your discussions that a written contract will include a termination clause. The next recommendation is to advise that employee to seek independent legal advice on any written employment contract and give them a reasonable time to obtain that legal advice. We typically recommend at least 1 business week if possible. This factor might not be determinative, and the adjudicator in this New Brunswick case might still have found that Dr. Dornan's employment contract was unenforceable, but it's still good practice, even especially for senior roles with large compensation packages where there is an increased amount of risk or liability attached. And finally, on that attention and consideration point, it's really important to make sure that an employee signs a written employment contract before they start work, even if it might mean pushing back the start date a few days to ensure that you have that signed contract in writing. If an employee works even 1 day before they sign that written employment contract, it could be unenforceable if it's signed at a later date. If it's not possible to execute a written employment contract before the employee's start date, You can still enter into a written contract after the fact, but the employer should bring to the clear attention of the employee any terms that are added to that written contract that they weren't obviously discussed prior to entering into that contract, and give them something new of value, like a signing bonus, in exchange for signing the written contract in exchange for those new terms of employment. It's also important to note that courts have clearly decided that continued employment or abstaining from terminating the employee alone is not adequate consideration for a new employment term. So it must be some new, fresh benefit that they're not already entitled to receive under the existing employment agreements. So that wraps up that issue on timing and consideration. So next we're going to look at fixed term contracts. Another issue that was presented in this case was the duration of the contract and thus the length of the notice period to which Dr. Dornan was entitled. As we mentioned earlier, the employment agreement was for a 5-year fixed term. So on your screen here, you should see a polling question. Absent a termination clause, what's the employer owe an employee whose fixed term contract is terminated during the term? If you'd like to click, you have the options of reasonable notice, the rest of the contract term, or the contractual notice period. Okay, so it looks like roughly just under half of you there said the rest of the contract term, which was actually the determination in this case. And so I will turn it over to Ian to discuss a little bit more of the reasoning in this present circumstance.
Thanks, Megan. So it's interesting that the answers were pretty evenly divided there among the 3 different options. The fact is that once an arbitrator determines, or if you do have a very clear fixed term contract, which has a defined start date and an end date, and you terminate, and that contract does not have a without cause provision, and you terminate it during the life of the contract, then the employee is owed the remainder of the full contract term. Normally, for many of you who are sports fans, this is where you'd see with coaches in professional sports normally have fixed term contracts. They get hired on it for a 2-year contract or a 3-year contract, and then if they're terminated during the life of the contract, then they're owed the full remainder of the contract. That might be a full year or a full 2 years. That's normally where you see those. In this case, it's a little bit, it's been a little bit overblown as to the fact that the New Brunswick government entered into a fixed term contract with Mr. Dornan, with Dr. Dornan, because they really didn't. They had a contract that had a fixed term in it, but that contract also had a termination provision in it that allowed for a much lower notice period if it was terminated without cause before the expiry date. But as we just talked about, the arbitrator determined that that clause was not valid, which then left it as an open-ended fixed-term contract. So certainly the takeaway from that aspect of it is that what I always advise clients is that fixed-term contracts are by nature very dangerous for the employer for this reason. If this contract had just been open-ended and not had a fixed term associated with it, then the arbitrator would have had no choice but to render some type of a common law notice period with respect to the termination without cause. If he ruled the clause invalid, he still would have had to determine a reasonable notice period that would have been much more traditional. But because the contract was a fixed term and said that it was a 5-year contract, and he's only 4 months into it, then he gets awarded the remainder of the 4.5 years. So the first takeaway that I would suggest is that we should avoid, if we can, having fixed terms or defined terms in the contract. But if we do, then we need to make sure that we have a valid termination provision, as Megan just said. So if you look at the next slide, if we just flip there we go. Thank you. It's much better, as I said, to have an indefinite term contract, because then reasonable notice would kick in and duty to mitigate would kick in, both of which are very valuable to the employer. But this arbitrator determined that once you have a fixed term contract, then the employee is owed the balance of the term if there's no termination clause, which is what I just talked about, and certainly extremely risky and creates a huge liability for the employer. And also, again, to use the professional sports analogy, there's no duty to mitigate if it's determined that you have a fixed term contract. So one thing that arbitrator Phillitter determined, which was correct, is that if you are in a fixed term contract with no termination provision, then there's no duty to mitigate. You are paid out the full value of the contract, even if you receive alternate employment. So quite an award with respect to Mr. Dornan Dr. Dornan being paid out the remaining 4.5 years of that contract for that reason. And again, in this case, it all happened because the termination clause in the contract was determined to not be enforceable. And just back to what Megan said, what I find about timing, what I find happens a lot in situations which many of you on the webinar would be familiar with, is that we enter into verbal agreements with folks, and then we might send a quick email to say we've agreed that you're going to be starting employment with us. And I think it's very important in that email to say, as Megan alluded to, that we'll be sending a contract, and that your employment is subject to finalizing the contract, the written contract. And if you do that, you'll be fine. And there was no evidence in this case. There was evidence of the oral conversation, and then there was evidence of the fact that Dr. Dornan signed the contract. But there was no evidence that there was any discussion after his first day or leading up to his first day that his employment would be subject to that contract. And it certainly would have saved the $2 million had somebody sent an email to Dr. Dornan that said, glad you're coming on board, but your employment terms will be subject to this written contract that we work out here in the next couple of days. Something to that effect would have closed that loop entirely. So if you do get a verbal agreement with somebody and they're coming on board and you want there to be a written contract, then just send a quick note by email to them that confirms that that's what's going to happen. So if we flip to the next slide, so the things to think about, or the lessons learned along this line, are that you want to think about whether you should have an indefinite term contract or a fixed term contract. I've already given you my views on that. I'm not sure that there's ever a value to having a fixed term contract for the reasons that happened here, because the employee is not held to the fixed term contract. They can leave with some notice, but the employer, as we can see here, if not properly crafted, can be held to the fixed term contract. It's much safer to have an indefinite term contract, because that means we fall back on common law notice principles if we don't have a valid termination provision in the contract itself. And also mitigation would kick in as well. So there may be, somebody could convince me that there might be situations where a fixed term contract is appropriate, but if you do that, then you probably should be getting legal advice to make sure that you're going to be able to avoid what happened in this case, and that you have a carefully crafted without cause termination provision. Somebody asked us already in the question box leading up to this as to why the provincial government of New Brunswick would be bound to a higher set of rules than other employers on termination provisions, which actually is not the case. I mean, what happened here could happen to any of you, for sure. But I certainly do not see many fixed term contracts in what I do, and for the very reason of what happened here would certainly suggest that people avoid them unless they're absolutely necessary. So that's where we are with the fixed term contract. I think I've sort of made my views clear on that. And again, I will finish where I started, which is it's a bit misleading to suggest that the New Brunswick government entered into a fixed term contract with Dr. Dornan without a way out, because they did put in the contract a very clear without cause termination provision that was determined to be invalid, which is what led to this outcome. So the final poll question is up next. So we'll put that one up. I think many of you will know the answer to this, but does it matter how you tell an employee their employment is terminated? Is that an important criteria at the time of termination? So I'll give people a second to answer that one, and then we'll move on with the final chapter of this, which is the manner of termination. So the vast majority of you said yes, and that's certainly where we are today. For any of you who have followed this issue for a number of years, 15 years ago, with the Wallace case, it became very much a live issue that the notice period could be extended by virtue of the manner of termination. So if you terminated somebody in a callous or disrespectful or demeaning manner, then the reasonable notice period could be added to. That concept was ruled, or subsequent case law said that was not appropriate, and that concept of Wallace damages kind of went away. And then we had the Honda and Keys case, which brought back into vogue the concept of the way in which you terminate somebody could lead to a separate head of damages called aggravated damages. People still call those Wallace damages, which is not quite correct, but it's an easy term for people to remember. But there's certainly no question that if you terminate somebody in an insensitive way, then it can cost you additional money. The $200,000 reward in this case is an extremely high benchmark for this type of thing. So that definitely has a chilling effect. Given that number is now out there in New Brunswick, I think you'll see, unfortunately, we'll see a lot of plaintiff counsel and wrongful dismissal actions now try to chase aggravated damages on the manner of the dismissal, given that this $200,000 number has been put out there. We all know that human rights damages in the Atlantic Canada are quite small in comparison. It would be 10, 15, 20,000 as the average kind of number. And now we have a $200,000 number out there for the manner in which somebody's dismissed. Is certainly going to cause a lot of people to, a lot of counsel to sit up and take notice and actively pursue a claim for these aggravated damages based on the manner of the dismissal. And so the one thing I agree with about this case, I don't agree with the number at all, but I do agree with the fact that the manner in which Dr. Dornan found out he was being dismissed from this high profile job could very much attract some type of damage, not to the extent that that was awarded, but I understand that it certainly was a meritorious claim. So what happened in this case is that Mr. Dornan was asked to attend a news conference the following day. He was told that he was getting told that the news conference was going to be happening. While he was on his way to the news conference, the employer called him and told him that his immediate supervisor had been replaced. The new supervisor then joined the call and told Dr. Dornan that he was being terminated and that he was no longer employed. And that occurred by phone as Dr. Dornan was on his way to the news conference, and then as he was in the parking lot, and then it was announced at the news conference that he had been terminated. And the arbitrator said that he was terminated in a public and disingenuous and callous manner that diminished his otherwise stellar reputation. And again, the other fact that came into play was that there had been a death in an emergency department in New Brunswick the day before. The premier made some comments about how the healthcare system had failed New Brunswickers, and then Dr. Dornan was fired, which could lead people to make the connection that Dr. Dornan was somehow responsible for what happened in the emergency department in Bathurst, and that caused the arbitrator to say that the manner and the damage to his reputation was severe, and the $200,000 award. So even though I agree that the manner of dismissal in this case was not appropriate, Dr. Dornan should have been brought in to a meeting in person. He should have been told in person that this decision had been made. There should have been some time distance between what happened in the emergency room and Dr. Dornan's termination, and they should have been, again, my last time, but to the sports analogy, there should have been some positive comments made about Dr. Dornan to the effect that the healthcare system in New Brunswick and the problems with the healthcare system were not Dr. Dornan's doing, but that it was time for a change, and he should have been thanked and complimented for the work that he had done, and people should have moved on, and it should have taken, the province should have taken a much higher ground. But what does cause me a great deal of stress and worry and concern is the size of this award, given the what is not such severe situation, where really the facts are that he was terminated over the phone just before the matter was announced publicly. Those are really the facts. Megan's going to give you some other fact situations that are much worse, that did not attract this size of an award. So I am worried about this. There'll be there'll be a ripple effect or a tidal wave effect to this decision, particularly. And the one way that it's going to impact the majority of you will be that plaintiff's counsel on employment dismissals will be seeking aggravated damages. So Megan's going to talk to you about how to make sure that we do our termination going forward in a way that we need to be able to avoid creating any type of opening for employees to pursue aggravated damages. So I'll turn it over to Megan to finish up on that point.
Thanks, Ian. So as Ian just said, the manner in which the employer terminated Dr. Dornan resulted in significant additional costs, $200,000 as aggravated damages in what was already a significant order for damages related to lost salary and benefits. And in addition to those facts that Ian just outlined, it's also notable that Dr. Dornan had significant difficulty in getting new employment after he was terminated in New Brunswick. He applied for a similar position in another province, and when that prospective employer reached out to officials in New Brunswick as part of a background check, they received very negative information, and so he was not awarded that position either. So obviously continuing conduct from New Brunswick did negatively impact Dr. Dornan's reputation. So the big lessons for you as employers that are broadly applicable would be remembering that the end of an employment relationship is often a highly emotional situation for both the employer and the employee. But courts have been clear that employees are particularly vulnerable at the time of termination, and employers have a legal duty not to treat employees unfairly, dishonestly, or insensitively at the time of termination or in the way that they terminate their employment. No matter the reason for or the circumstances of the termination, be respectful and professional throughout, or the costs against the employer could be high. So, although this case is a strong example of the risk to an employer if they fail to proceed with terminating an employee in a good faith manner, although albeit at a much higher cost than what we've seen in the past, it is by no means the first or only example. So a few decisions from Ontario within the past year have also awarded aggravated, or another word for it is moral damages, or punitive damages against the employer where the termination was carried out in bad faith. So one of those decisions comes from 2022, and that's out of Ontario, in a decision involving the Hudson's Bay Company as the employer. In that case, $45,000 in moral or aggravated damages were awarded, in addition to $10,000 in punitive damages were ordered against the employer for its bad faith conduct in termination. And that conduct included escorting the employee out of the workplace upon termination without justification, making a misleading employment offer that was confusing to the employee and then revoking that, delaying payment of legislated employment entitlements, and issuing a delayed and inaccurate record of employment when it was eventually issued. And another Ontario decision, which comes just this year in 2023, involves the Aurora Hotel Group. In that case, there were $15,000 in moral damages awarded against the employer for its failure to comply with employment standards legislation, improperly withholding expense reimbursement, and promising to pay more severance, but then ultimately only paying the minimums pursuant to employment standards legislation. So obviously that presents a number of other risk factors related to bad faith conduct that could impose additional costs and liability on the employer. As a result, the biggest takeaway on this point is that any conduct that is unfair, heavy-handed, or harsh could be deemed to be bad faith and result in additional costs awarded against the employer. Treating an employee respectfully, no matter how difficult the circumstances of the termination, is certainly best practice to reduce risk and liability. So that concludes this portion of our presentation, but I believe we have a few questions in the question box there that we can turn our minds to now. And if you have any additional questions, please feel free to pop those in the question box now.
So thank you, Megan. So we do have, we did want to leave 15 minutes for questions. So feel free to to send your question in. But as Megan said, we do have some questions here that we're going to answer. So the first question, which is an excellent question, is wouldn't a maternity fill-in position be a good time to use a fixed-term contract? I did say that I really couldn't see a time when you would want to use a fixed-term contract, and this question excellently points out the deficiency in my comment, because a fixed-term contract doesn't make sense for what is obvious to you as a fixed-term position. So if you have a position that is a maternity fill-in, that is a 1 year or an 18-month or a 9-month position, and you know that as a fact, then it's a good idea to use a fixed-term contract and to tell the person that they have a defined start date and an end date, and then you can, and that way the contract can end on the end date without any further notice being provided. It's important, though, in that fixed-term contract, when I always draft them or redraft them for people, to make sure you say clearly in the fixed-term contract that the contract is going to end on the end date without any further notice being provided to the employee, either by severance or in lieu of severance. You need to be very clear about that, number one. And number two, that contract should also have in it the ability to terminate it on a without cause basis. So if there's a reason that you no longer wish to employ that person, you need to have a way out. So it should have both those things in it. It should say the contract will terminate at the end on the defined end date without any further notice, and it would also say that you have the ability to terminate it on a without cause basis by providing X amount of severance. Whatever you determine, the best way would be to say Labor Standards Code notice, depending on your province, and end it that way. So that's an excellent question. I would use a fixed-term contract if you have a defined length of time, like a maternity fill-in. But it's important to remember those 2 points that I just referenced. So the other the other question that we have here is similar to what I just said, but I'll let Megan answer, is what would be included in a good termination clause in a contract that would be fair to both sides. So I'll let Megan take that one.
Sure. So that's really dependent on a number of different factors, one being the position. Certainly in higher positions like this one, it might be more common to negotiate what termination would look like. And for a CEO, that could be a guaranteed 6 months pay in lieu of notice, or 6 months notice, or 12 months notice, whatever is negotiated by the parties and determined to be fair. Where we see kind of the most focus, particularly in the courts, who have highly scrutinized without cause and just cause termination provisions over the past number of years, are where employers are attempting to limit termination entitlements to only those minimum entitlements under the applicable provincial employment standards legislation. And so in order to do that, there's certainly careful language that we recommend employers include in those kinds of termination provisions. One being that it must expressly contract out of common law, and that the employees agree that they are receiving only the minimum entitlements and they're waiving any further entitlement to any other payment, including under the common law. And part of that language is also going to vary slightly from province to province, and what is required by the minimum employment standards legislation. So we certainly recommend that you reach out to one of us or your employment counsel to determine what might be required in the circumstances for you.
Thanks, Megan. So we do have a couple more questions here. So somebody, I'll take the next one, which is a little bit off topic, but someone did ask in advance about if you have a staff member that is underachieving based on their job description, what are the next steps with respect to dealing with that person? And so certainly dealing with underperforming employees could be the subject of an entire webinar, but I will just give a few pieces of advice on that. To me, having done a few arbitrations in the union context and dealing with these in the employment law context recently, what's very important is that step number one has to be to provide what I refer to as a gap analysis or a gap letter or email. So there has to be clear documentation that the employee was showing where the gap is between their expected job performance in their as contained in their job description or just generally, and where they're performing and where they're currently at. So the employee has to have a clear understanding that there's a gap between expected performance and their performance, and the gap has to be clearly understandable not only to you and them, but to a third party as well, that they can read your letter or your document and see that there's a clear gap between what's expected and what's happening. Number two, the employee has to be specifically told how they can close the gap or what steps need to be taken to close the gap, that they need to do X, Y, and Z better, differently, need to achieve certain results, but there has to be definition of the gap, number one, and number two, the steps that need to be taken to close the gap. And number three, they need to be told or given or provided with the opportunity to ask for assistance to close the gap. So you would say, if you don't understand or need help, or you have you don't understand how to close the gap, then please feel free to reach out. So that's number three, is they have to be given a lifeline that they can avail themselves of to assist them in closing the gap. And number four, they need to be told that the matter could become disciplinary if they, within whatever is reasonable. I normally say a 3-month window, but it could be shorter in certain circumstances. They need to be told that if they're unable to close the gap within a reasonable period of time, let's say 60 to 90 days, then the matter would become disciplinary. And then once it becomes disciplinary, you issue some type of discipline, normally a written warning, and you repeat the same steps again. So that's my Cole's notes as to how to deal with an underperforming employee. But step one has to be non-disciplinary, and it's got to cover the 4 points that I just mentioned. And then that all happens, and then you can move to a disciplinary response, but follow the same factors in your mode of progressive discipline. So that's my answer to that question. And I think we'll take one more question unless somebody wants to send one into the chat line. I think the last one we'll take, which I'll give to Megan, is this issue of aggravated damages. Does that apply equally to a management employee as compared to a frontline employee?
Yeah, exactly. So I think based on what we've seen from those cases that we've outlined, whether you are a retail employee who's treated poorly or you are the CEO of a health network related to government, clearly you are, as an employer, you have a duty to treat that employee in good faith, and that includes the manner in which you terminate them. So regardless of whether they are a CEO or a very low-level employee, you could attract some kind of damages if you treat them negatively or harshly or are heavy-handed at all in relation to the termination of that individual.
Okay, thank you. And so I think that covers all the questions that we've received. So lots of thank you all for joining us, and lots of takeaways from this decision in New Brunswick and lots of lessons learned, which is why we thought it would be topical to get out there and with you folks and talk about it. But I think just to sum up, that the most important takeaway for me is that this issue of aggravated damages is something that could impact all of us, all of you, and so we need to be very, very careful and thoughtful at the time of termination, even if the termination is without cause and we're paying damages. We still need to be very respectful of how we go about terminating the employee and be very aware that any type of misstep could end up costing us additional money. And so we just need to make sure we act in good faith and that we act respectful at all times. And so I think that's the biggest takeaway for me. And with that, thank you all for joining us. And we certainly are pleased that you did, and keep your eyes out for further McInnes Cooper webinars on employment topics. So thank you to Megan, and enjoy the rest of your day. Thank you all very much.
Thank you.